Hello, my name's Andrew Stewart from Adelaide Law School. I've spent a lot of time in the past 2.5 years, along with my colleague, Professor Rosemary Owens, looking at the regulation of internships and other unpaid work experience arrangements. We were asked by the Fair Work Ombudsman, which is a government body responsible for enforcing our fair work legislation, to prepare a major research report on this issue. And here it is. The report looks at what we know about how many of these arrangements there are in Australia. There's no hard and fast data, but what we can say is that a very significant number of people are now undertaking these arrangements, and it appears that the number's growing. Some industries, media, film, fashion, it seems like this kind of arrangement's been around for a long time, decades even. But in other areas, particularly professional areas, law, accounting, finance, event management, PR, marketing, in fact any area where you've got an oversupply of eager young graduates competing for jobs in a very tough labour market, it seems like more and more job seekers are willing to work unpaid to get their break. Unfortunately, there's not a lot of certainty about what's lawful or unlawful in this area. The only thing we can say for sure, and this is because there's a provision about this in the Fair Work Act, is that it's perfectly okay to work for nothing if you're doing so as a required part of a recognised educational training course. So whether that's at university, TAFE, any other kind of training program, that's okay. But we found in our report that there were many job seekers who are now undertaking unpaid internships or other work experience outside the course. Do they have to be paid? Well, it depends on whether they're an employee. There's no statutory definition of who's an employee. It depends on certain principles developed by the common law, that is, developed by the courts. And the key question is, are you doing the work as part of a contract? Do you have an obligation to come to work? Now, what cases there are that have come before the courts, few and far between on this issue. But what we can say is that there's certainly a good argument that if you're doing productive work for an organisation, it's not just sitting around watching what's going on, you're doing work that's benefiting the organisation, and it's work of the kind that would otherwise have to be done by a paid employee, then there's a very fair chance that you really are an employee. If you're an employee, that means you should be paid for your work, and other entitlements under the Fair Work legislation apply. Ultimately, this is only going to be settled if we see some test cases come before the courts, and we're expecting that there will be some more cases in this area, not least because of our and the Fair Work Ombudsman's interest in this area. But we've already seen some major cases overseas, finding in countries like the UK and the US that unpaid interns are employees and are entitled to at least a minimum wage. So some people might say, if a person chooses to work for free, well, what's wrong with that? Well, we're not talking here about somebody volunteering their services for a cause or for an organisation that they believe in or want to support. It's a self-interested arrangement. And there are at least two reasons to be concerned about people agreeing to work for free, particularly in an arrangement that's not part of an educational training course. One is that it potentially undermines the integrity of our labour laws. If it's not lawful, and it isn't, to work for less than the minimum wage for a particular job, why should it be lawful to work for nothing? But there's also perhaps a more important social issue here. If we see that it is becoming harder and harder to get a job in a particular profession or industry without doing a lengthy period of unpaid work, well, who does that benefit? Benefits the people who've got independent means or have got families who can support them. Makes it that much harder for people from lower socioeconomic backgrounds to break into the industry or the profession of their choice. We're making a tough labour market even tougher for people in that category. So I guess the final question then is, how should we be regulating internships and unpaid work experience? Well, in the long term, there's no doubt in my mind that the best solution would be to amend statutes like the Fair Work Act to deal with this issue explicitly, but that's not going to happen anytime soon. So what can we do in the meantime? Well, the Fair Work Ombudsman's already working hard to develop some more educational materials to provide more advice and information. And it's also working with industry groups to see if it's possible to develop some sensible guidelines for internships and work experience. And I do think that's the best way to go. We may need to see some cases come before the courts, but rather than the sledgehammer approach of taking employers to court, I'd rather see industry bodies working cooperatively with other stakeholders to develop sensible limitations. I think people in the community would say that we don't want to stop job seekers from taking the initiative to get work experience, to find the kind of contacts and information that might help them get a job. But we do want to have some sensible limits. We do want to make sure that work experience doesn't turn into work exploitation.